And we are just ready to jump straight into our civils.
Yep, and I've got um, Preferred Credit Union versus Franthia Price next. Is that all right? We are here in the case of Preferred Credit Union versus Franthia Price, case number 25-05340AE. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter is before the court for a motion today, although it was not clear to me what the nature of the motion is. So as an initial matter, Ms. Price, would you state and spell your full name for the record, please?
I just want you to know, Your Honor, I'm here specially, not generally, and do so sui juris as the authorized agent for the Franthia family of the Price estate. So my appearance is strictly limited to the matter noted today, and it does not grant any joinder to general jurisdiction, nor does it have any waiver of rights or imply legal disability or association with any bar guild.
Well, I get it, Ms. Price. However, I can tell you that I'm a general jurisdiction court. I operate under the United States Constitution and the Michigan Constitution, and those are the only things that give me jurisdiction to act or make any decisions. So if you want me to decide anything in your case, you're going to have to be within the jurisdiction of my court. So, and we don't have to hammer that completely out at this time, but I do need you to state and spell your name.
Franthea, Franthia.
All right. Last name Price, Price.
I am.
Very good. And Mr. Bakukio, would you place your appearance on the record, please?
Thank you, Your Honor. May it please the court, Stephen Bakukio, Buquicchio, P number 62076, on behalf of the plaintiff Preferred Credit Union.
Very good. And Mr. Bakukio, this is not your motion. This is Ms. Price's motion.
It is, Your Honor, although like you, I'm a bit confused as to what the relief she's seeking here. So I'm prepared to assert Preferred's position legally here, and we'll wait for the court's direction as to when I can speak on that.
Very good. Well, let me go back to Ms. Price, because it's her that initiated this motion appearance. What are you asking me to do at this time, Ms. Price, in a legal sense?
I respectfully request that the court take judicial notice pursuant to MRE 201B of the following two documents I previously filed into the court record. One is Exhibit J, OC 10, subpoena ducis tecum, demand for custodial records. And number two, supplemental notice of clarification regarding the constructive subpoena ducis tecum. These materials, Your Honor, are supported by the Federal Reserve Operating Circular number 10, Appendix 3, UCC Article 8, subsections 8, 102A, 14, and 15, 12 CFR, subsections 225 and 31 CFR, subsection 203, which collectively...
Let me just pause you just a minute, Ms. Price. The one thing I recognized of everything you said there was the Michigan Rules of Evidence and the term subpoena ducis tecum, meaning you're directing a discovery subpoena. Is that directed at Preferred Credit Union?
It is, sir. I also wanted it to be on record because I previously asked for debt validation and didn't get anything in the lower courts. So,
okay.
Your Honor, may I respond?
Yeah, go ahead, Mr. Bakukio.
A couple things, Your Honor. There's a lot to unpack there. Number one, we have a judgment in this case. So any attempt for discovery is outside, respectfully, the jurisdiction of this court at this point. I suspect what Ms. Price or the estate of Ms. Price or the Franthia Price family of Price estate is seeking to do here, Your Honor, is undo the judgment that was legally entered in the lower court case. So I would just say, Your Honor, what she's asking for is irrelevant and outside the bounds of what this court can do. The case is over as far as the district court is concerned. I can get into the argument as to the debt validation. I did produce with our response, a motion for summary disposition there that did provide for the debt validation notice. Ms. Price continues to mislead the lower court and now this court that a debt validation was not given. It was in fact given. This is a simple credit card case, and she is trying to use far-flung, I can't even characterize what these arguments are, Your Honor. I want to be respectful of Ms. Price's ability to defend this in pro per, but
I object, sir. I'm not in pro per. I'm sui juris. Thank you.
okay, whatever that means, Your Honor, this is making a $12,000 credit card case so much more for my client, and Ms. Price, pursuant to the agreement, is responsible for those attorney fees. And I know there's a fine line between allowing a defendant in pro per or sui juris or whatever the name she's calling it, but this is just abuse of the process, Your Honor. She is alleging things that have no legal bearing whatsoever. She's asserting UCC, bill of cost, bill of ladings, bill of exchange, foreign bill of exchange. Your Honor, I don't even know what this means, to be quite honest, and I've been doing this for over 25 years.
Let me just pause you for a minute, Mr. Bakuko. Something I did see that I did recognize as I paged through the file was the affidavit of a transcript of the lower court record, which is normally produced in a case that comes before me on appeal of the district court decision. Are you aware of a notice of appeal filed?
I am not aware of that, Your Honor. I suspect what was done here, Your Honor, was in the lower court. The judge indicated to Ms. Price that she's ruling in favor of preferred and she was welcome to appeal that. And I suspect this is her attempt to appeal that. And to the extent Your Honor is ready to rule on her appeal and either, overturn the lower court's decision on the judgment or some other ruling here, I'm going to proceed as though she is seeking to undo the judgment that was entered against her. That's all I can surmise by this, Your Honor.
Yeah,
Okay.
if I may speak.
Yep, go ahead, Ms. Price.
I believe the opposing counsel has stated he has not received an appeal. I have sent that, all the information you received. He's received that. I have the record, that the hard copy receipt from the post office. I sent this certified mail. So I do have the receipts of all of those things. Whatever you have, his office received it as well. I do have the proof of service and all that. The fact of the matter that he continues to mischaracterize this as solely a simple credit card debt that I'm trying to avoid, that is simply a mischaracterization of what I'm attempting to do, as is unsupported on the record that I've attempted through bill of exchange, and I've asked and requested and have not received a simple application. A copy of it is not supported of the verification that this is a bona fide contract, and lawful consideration, if it's not done, is violation of a contract as well.
All right. Well, here's my where I sit on this one, Ms. Price, is that my position legally here is I'm the court of I can sit as the Court of Appeals to review the judgment in the district court. And what I appear to have in front of me here is a partial appeal, in that I do have the record, at least at what looks like to me, it's not a full record, it's just a transcript of the summary judgment hearing at the in the district court in Kentwood. Normally, when I get the record from them, it has a whole bunch of other documents that explain, in a nutshell, how that case was reduced to judgment. And I don't have that, so I don't appear to have an entire record. And what I don't have from you specifically is a document called a notice of appeal that tells me that you're appealing a final judgment and that you want me to review that for its legality. I can tell you, because it is on appeal, it follows the appellate rules of the Michigan court rules, and they are, for lack of a better term, more intricate and harder to follow than the general court rules or the court rules for proceeding in the district court or in the circuit court. There are a lot more hoops to jump through on appeal, and that's really where you are when you're in front of me. And I can also tell you that on appeal, what I'm supposed to do is look at the record that was generated in front of Judge Sturkenberg, and the new stuff that you file with me, arguments or requests for discovery. Mr. Bequicchio is accurate in saying that normally you don't get any additional discovery on appeal. Normally what you do is you make an argument on what happened below, and that might include that Judge Sturkenberg denied you proper discovery, and that thus she made a legal error that warrants me overturning that case or sending it back to Judge Sturkenberg for more work or things of that nature. And I can tell you, from what I see in the file right now, I don't have the information I would need to decide that. So what I am going to do is direct you to file the requisite notice of appeal and appeal documents within the next 15 days, or I will dismiss the appeal, and you'll have to start that process over again. And the dismissal may have a substantive effect on your ability to file another appeal. So what I'm telling you is this appeal that's in front of me right now is incomplete. It's not documented per the appellate rules, which are found in the Michigan court rules. And, I wouldn't have any choice but to dismiss it unless you supplement it with at least bare minimum a notice of appeal and sufficient information to inform me and Mr. Bequicchio what the nature of your appeal is. What it appears that you're appealing from a final judgment. However, all I saw in the final judgment, I think, was the fact that Judge Sturkenberg did grant that on the record. I didn't see. Do you have a judgment in order that you filed, Mr. Bequicchio, a written order in connection with that?
We do, Your Honor. A judgment was indeed entered subsequent to our motion for summary disposition and hearing on that motion, and I believe that was submitted with our response to Ms. Price's filing, whatever that was, Your Honor.
Okay, and unfortunately, I have Ms. Price's filing. I don't think that I have your response. It didn't make its way to me in time to come home with me for the file. So I'll review that as well. But Ms. Price, like I say, there is documentation. And it is strictly required by the appellate rules. There's no way, sometimes in the lower courts, a judge can say, well, you're appearing as a sui generis pro se, a person appearing without an attorney appearing beside them, and I can give you a break on following some of the rules. That's not true at all on appeal. Appeal there, either you follow the rules or your appeal gets dismissed. It's kind of a black and white system in that regard, and that it doesn't give me very much discretion when I'm sitting in that appellate jurisdiction. So you do need to get that in order, and I'm going to have it ordered that it be done within 15 days. That's, I think, all we can do for today.
Your Honor, as a procedural clarification, Your Honor, to the extent Ms. Price does supplement her appellate filing and the court finds that it is inconsistent with the appellate rules, will another hearing be required, Your Honor? Or
no, I'll just sign an order of dismissal if I don't have the proper documents to initiate the appeal.
Terrific. Thank you, Your Honor.
Very good.
Your Honor, you said I have 15 days to get the information because I believed I sent all of this stuff in appropriately. I went into and handed it in and got the proper documentation And the fact that you said you don't have that information is a little.
Yeah, no, I do have
remiss
a bunch of
about it.
stuff that you filed that appears to have been printed out by you. The one thing I have, and the only suggestion I can make, Ms. Price, there is a legal assistance center on the fourth floor of the courthouse. If you talk to them and say, gee, Judge Rossi said I was missing some stuff on appeal, they can at least direct you to the proper forms to file to initiate an appeal. Because the one thing I did receive here was the notice of filing of transcript and affidavit of mailing, and that's on a Michigan court form that I recognize. And what I then got was a transcript of that hearing, the last hearing, it appears, in front of Judge Sturkenberg. However, there is more stuff. They need to, what really they need to do is transmit the entire record of that case, or you as the party need to assemble that record on appeal, the record of what happened in the lower court, and get it to me on appeal. And that basically looks like those transcripts plus any paper documents in the court file that happened in the district court. And I don't see any of those in my appellate file here.
They told me that I put there that they was going to mail it to you. They mailed me a copy, and they said they was going to mail you a copy because I purchased the transcripts and everything.
Yeah, and I did get the transcript, but that's just the transcript of the the hearing on appeal, and that is part of what I need. I said I didn't have a claim of appeal. I stand corrected as I'm paging through here. And I have to tell you, Ms. Price, the filing of the additional documents here, I know you believe it's important in helping me to decide your case, but I can tell you what it's doing in a practical sense is making it really hard for me to file, just to track the documents that actually do trigger my duty to decide stuff on appeal. So I do have a claim of appeal. Looks like it was signed by you on June the 13th of 2025. So really what I need on appeal then, and again, I'm also prohibited, as the folks at the Legal Aid Center are, from giving legal advice. But I can tell you, if I'm to decide any appeal, I'll need a copy of the entire lower court record on appeal. And the record on appeal, like I said, usually it's assembled by the parties to the appeal. Usually you, as the person, the individual appealing the decision of Judge Sturkenberg, are the one that's going to put that together. Mr. Bequicchio can contribute to that record if he wishes to do so. And then that gets submitted to me, kind of as a, here's what happened at the lower court. It tells the story of that in those filings and pleadings filed at the lower court. And then you file a brief on appeal, and your brief makes the arguments as to why Judge Sturkenberg made legal errors in her decision making. And since I'm requesting that brief now, I just thought I was needing the claim of appeal, but since I have a claim of appeal that properly initiates the case on appeal, what I really need then is that record on the lower court, and then I need a brief from you explaining the errors that you think Judge Sturkenberg made. And I'll tell you, I will not be receptive to documents telling me that Judge Sturkenberg or I didn't have jurisdiction. That would be in effect saying, Judge, I'm arguing that neither of the courts could really decide this case because of my legal status, sui generis, or whatever magic words you're trying to invoke there. That just doesn't work. And the reason it doesn't work, particularly on appeal, is I have to have jurisdiction to decide the appeal in the first place. And if you're telling me I don't have jurisdiction, you're as good as telling me, as judge, dismiss my appeal because you can't decide it anyway. And so in other words, you got to give me more than that. It's got to be an argument based on Michigan law as to what mistakes were made by Judge Sturkenberg in the court below, and then I can decide the matter on appeal. And since I'm looking for the brief on appeal, that's a little harder to put together along with that whole record. I'll extend the time for the filing of the record on appeal and your brief on appeal. I'll give you 60 days from today's date. We're at July the
25th.
25th. Yeah, sorry, my glasses. I'm using a backup pair of glasses because my regular ones are in the shop. So 2 months from today will bring us to September 25th to have those documents filed. And then I'll be able to decide those. And I'll also tell you, Ms. Price, the way it works on appeal is I don't need to grant. You can request oral argument, which would be another version. Today, really, this is more of a status conference. It's not so much oral argument because I couldn't make head or tail of what the file was asking me to do. You can request oral argument if you want it. I don't have to grant it on appeal. Sometimes I just review the record and the filings and, decide the appeal based on that. And of course, Mr. Bequicchio, after that 60 days can file whatever he wants in response to your arguments on appeal. And likely that'll be a motion to dismiss the appeal saying Judge Sturkenberg did everything right and there's nothing to look at here, folks. So that's kind of how it works on appeal, just for your information. And like I say, if you need help with at least the forms part of it, the Legal Assistance Center on the 4th floor of the courthouse is a good resource for that.
Okay, so am I, just for clarification, because I'm going to do this right this time, this coming next time. There's 60 days you need the brief on appeal explaining the errors of the lower court.
Correct. And the record.
And you need a complete record of the 2 hearings that had taken place.
I need the complete record from the lower court, and that would start with everything from Mr. Bequicchio's complaint that he served you with and the proof of service and all that stuff. Typically, there's a copy of it. Would be as if you grabbed the file from Kentwood and made a copy of every piece of paper in it.
Okay.
Plus the transcripts.
Okay. Plus, you still need the transcripts as well?
No, you already filed the transcript. If that was the only hearing in the case, were there other hearings?
There were none, Your Honor.
Okay, so that was the only time that you two argued in front of the judge. So I don't need any additional transcripts. I just need the record on appeal.
Your Honor, there may have been a pretrial. I can't remember whether or not that was on the record or not, Your Honor. But if it is indeed on the record, the lower court record would include that, of course.
Very good. All right, so that's what I need, is that record from the lower court. Mr. Bequicchio, I think the appellate rules allow you to weigh in and supplement the record or collaborate on submitting the record to me. I'll leave that to you as to how much you're going to participate and assist with that production. But you two can talk to each other. The goal being to get everything in front of me that I need to decide the arguments that you make in that brief on appeal, which is where you get a chance to make your substantive argument as to any errors made by Judge Sturkenberg.
Thank you, Your Honor. I will say, to clarify from our position, we did respond to the filing of Ms. Price. With that, we included the complaint, the answer, and our motion for summary disposition, and Ms. Price's response to that motion for summary disposition. So that should make its way to the court file. I don't know whether that would be deemed an official record as far as the appeal is concerned with certified documents, but we did put the underlying materials in our response. So that will be contained in your file. And
copy obviously went to Ms. Price, so she should have received all those filings as well. And normally, right, there is the certified record on appeal gets a simple one-page document from the district court saying this is everything we have in our file. So I would accept either way. If you want to supplement what Mr. Bequicchio sent Ms. Price, or whether you want to just go to the district court and say, hey, I need a whole copy of that file because Judge Rossi's asking me for it, and it's got to be certified because it's on appeal. They at least have done that before down there at the Kentwood Clerk's office, so it'll at least give you a starting point as to what to do. And like I say, I think I'd make my first stop the Legal Assistance Center so you can walk in there with the right form when you go to Kentwood District Court.
Thank you. And then do I use the same case number as well?
No, it'll be assigned and it already has been assigned a new case number on appeal, which is the one we're here on today. It's 25.
Yes, that number, that's the one I'm speaking of.
Yep, that is the appellate case number.
Okay,
Now, when you're talking to Kentwood and if you're looking for
It's
the
a different
court
number.
record, then you got to
Yes.
go with that number down there.
okay, thank you. I appreciate your help, sir.
Very good. Good luck to you, ma'am.
Thank you.
Thank you,
you.
Your Honor. Thank you, Ms. Price.
So let's break down what actually happened here. Franthia Price lost a credit card debt case in the lower court, roughly $12,000 owed to Preferred Credit Union. The district court judge ruled against her, and a judgment was entered. Now she's trying to fight that decision on appeal. The problem? She showed up using language the court doesn't recognize, calling herself an authorized agent for a family estate, invoking sui juris status, citing Federal Reserve circulars and UCC codes. The opposing attorney, who's been practicing law for over 25 years, told the judge plainly he couldn't even characterize what her arguments were. And that's really the heart of this situation. Miss Price clearly believes she's doing the right thing. She filed documents, she purchased transcripts, she sent everything by certified mail. But the appeal was incomplete. She never filed a proper brief explaining what legal errors the lower court made. She never assembled the full record from the district court. And the arguments she did raise, about jurisdiction, about bills of exchange, the judge told her directly those won't fly. Now here's the key takeaway. Judge Rossi didn't throw her case out on the spot. He gave her 60 days to get it right, file the complete lower court record and a proper brief on appeal that argues real legal errors under Michigan law. He even pointed her toward the Legal Assistance Center on the 4th floor of the courthouse. But make no mistake, this was not a win. This was a lifeline. If she doesn't follow through correctly within that 60-day window, the appeal gets dismissed and that judgment stands. And the judge made it clear, on appeal, there are no breaks for not knowing the rules. You either follow them or you lose. So if you've been following cases like this, where people try to use unconventional legal theories in court, pay attention to what happens next. Will she get her paperwork in order, or will the clock run out? Let me know what you think in the comments. Drop a like if this was helpful, and subscribe so you don't miss the follow-up. We'll be watching this one.